Hello everyone, my name is Lenna Pearce-Wilson and today I'm going to be discussing one of the fundamental cases in Australian tax law history to scrutinise the definition of assessable income. This case was between the Federal Commissioner of Taxation and Dixon as found in volume 86 of the Commonwealth Law Reports beginning at page 540. This case determines whether amounts paid by a former employer when making up the difference between military wages and wages paid under an employment contract are assessable to the individual. To begin, we must first look at the facts surrounding the case. Fletcher Clendon Dixon, from here on just be referred to as Dixon, was an employee of Messrs McDonald, Hamilton & Co., which from now on will just be referred to as the company. On the 22nd of September 1939, a quote was inserted into the company memorandum informing all employees that they intend to compensate staff who enlist in the war. To ensure employees are not financially disadvantaged as a result of serving for their country, the company endeavours to make up the difference between their military wages and their current wage paid by the company at the time of enlisting. The employer was not compelled to make the payments, nor was there any guarantee that these payments will continue for the duration of the war, but merely that the company will attempt to do so. Dixon read the inserted quote and, on the 12th of July 1940, voluntarily enlisted in the Australian Imperial Forces. At this time, Dixon was employed as a clerk in the company's Sydney office and received an annual wage of approximately £245 Australian and 14 shillings. At the time of being called upon for service, Dixon's employment with the company was terminated. Consequently, his salary was no longer paid. There was no assumption or guarantee made by either Dixon or the company that once discharged, Dixon would return to the company, nor would a position be available to him. The year in question in this case is from the 1st of July 1942 to the 30th of June 1943. The company upheld its plan and paid £2 per week, equating to £104 for the tax year in question. This amount was not paid directly to Dixon. Instead, he instructed the money to be paid to his former colleague still employed by the company, who then gave the money directly to Dixon's mother. At the end of the year, Dixon lodged his tax return with the ATO, reporting total assessable income of £321, which includes the £104 payment from the company. He then promptly lodged an amendment to exclude the £104, reducing his taxable income to only £217, stating it was instead a gratuitous gift from a previous employer. On the 17th of July 1944, the Commissioner of Taxation issued Dixon with a notice of assessment outlining a tax liability of £26 and 13 shillings, resulting from a taxable income of £223. This includes the £104 receipts. Note, the reason for not being assessed on the full £321 is due to defence wages generally being exempt from income tax in Australia. On the 5th of August 1944, Dixon objected this decision, arguing that the assessment is not based on the amended return lodged by himself, further stating the additional money paid by the company was a personal gift and therefore not subject to income tax. Then, on the 15th of November 1944, the Commissioner disallows the objection on the grounds that the money was in fact assessable income derived by the taxpayer. Dixon, being dissatisfied at the decision, requests that his situation be referred to the Board of Review for their opinion. As such, the Commissioner obliged. The Board of Review agreed with Dixon and upheld his objection, stating the notice of assessment should be amended to exclude the £104. The Commissioner, still believing the receipts constitute assessable income, appealed to the High Court of Australia, where the case was heard by the full High Court in Sydney on the 18th and 19th of August 1952. The issue at hand is whether the £104 paid by way of compensation for foregone wages when enlisting in the Army by a former employer constitutes assessable income under either Section 25(1) or Section 26(e) of the Income Tax Assessment Act of 1936. The full High Court was required to contemplate whether recurring periodic payments, expected and relied upon by the taxpayer, sufficiently satisfies the meaning of income within the spirit of the law. To do so, the Court was required to look at several provisions within the 1936 Income Tax Assessment Act. Firstly, the Commissioner argued that the payments were assessable under Section 26(e), but for his employment with the company at the time of enlisting, he would not be in receipt of the £104. Section 26(e) states, the assessable income of a taxpayer shall include the value to the taxpayer of all allowances, gratuities, compensations, benefits, bonuses and premiums allowed, given or granted to him in respect of or in relation, directly or indirectly to, any employment or services rendered by him. The employment that the Commissioner relied upon was with Messrs McDonald, Hamilton & Co. for services rendered in the past prior to enlisting. not for services provided whilst being a soldier. The court agreed that the payment was in fact some form of allowance, gratuity, or benefit provided by the company. However, they had difficulty in agreeing that the historical employment relationship between Dixon and the company sufficiently satisfies the conditions set out in Section 26E. Justice McTiernan responded to the Commissioner's but-for argument by stating the current circumstances do not depict the sum flowing from Dixon's employment. Instead, it is a voluntary contribution provided as a result of the personal and social relationships developed between an employer and employee to ensure that staff do not suffer financial loss when enlisting in the Army. Justice Fulliger responded by saying the payments cannot be in relation to employment as the offer was made to all employees, irrespective of their time served or position held within the company. As such, no actions by Dixon justify the payments. Merely his employment with the company allowed him to be selected as a recipient for the payments. Consequently, it was unanimously concluded that there was an insufficient nexus between Dixon's employment and the receipts to constitute income derived from employment or personal exertion as per Section 26E of the 1936 Act. The next provision in question is Section 25(1). It is here that the court was unable to form a unanimous decision as to whether the amounts should be assessable to the taxpayer. Ultimately, a majority decision from 3 justices decided that the amounts do in fact constitute assessable income. Section 25(1) states that the assessable income of a taxpayer shall include a. Where the taxpayer is a resident, the gross income derived directly or indirectly from all sources, whether in or out of Australia, and b. Where the taxpayer is a non-resident, the gross income derived directly or indirectly from all sources in Australia, which is not exempt income. In applying this provision to Dixon's circumstance, the court first had to determine what is income. Unfortunately, income is not defined within the 1936 or the new 1997 Act, giving rise to uncertainty and ambiguity within the meaning. The court referred to Section 6 of the 1936 Act to define assessable income as all amounts included in a taxpayer's assessable income due to any provision of this Act. In translating this to today's provisions in the 1997 Act, Section 6(1) defines assessable income to include all ordinary and statutory income of a taxpayer. Reference was made to the case between Scott and the Commissioner of Taxation as heard by the New South Wales Supreme Court in 1935. It was here Chief Justice Jordan noted that although income is not defined within the Act, it does illustrate examples of various receipts that are considered to be income. To determine whether an amount is income by nature, consideration must be given to the character of the receipt from the taxpayer's perspective, rather than the character of the expenditure incurred by the payee when providing the payment. In a joint judgment delivered by Chief Justice Dixon and Justice Williams, emphasis was placed on the recurring periodic nature of the payment. The purpose of the payments was to enable the taxpayer to support themselves and their dependents at a level previously capable of. Both of these factors bear a striking resemblance to the frequency and purpose of wages being paid to employees. They then went on to say that the current situation falls outside the conditions outlined in Section 23S. Here it states the pay and allowances of members of the Australian Navy, Reserves or Air Force is exempt from income tax, provided it is received in their military capacity. As it has already been established, the £104 was not paid for services rendered as a soldier. Therefore, Dixon cannot rely on this exemption. Oppositely, Justice McTiernan argued in his dissent that the £104 should not be included in Dixon's assessable income. To form this view, McTiernan referred to a case from the United Kingdom between Stedford and Bellow as decided in 1932. Similar to Dixon's case, Bellow was in receipt of periodic payments from a former employer. Bellow was a headmaster of a college for 14 years, during which he received an annual salary of approximately £1,000. Upon his retirement in 1928, he was granted an annual pension of approximately £500 to be paid quarterly. It is important to note that the college had the right to rescind the pension, therefore stopping payments at any time. In 1930, the Commissioner included the £500 in Bellow's assessable income. When the case was heard before the High Court of Justice in London, it was held that the payments were not actually assessable income. Lord Dunedin stated that the pension was a casual gift resulting from somebody else's goodwill. The fact that the payments were periodic only meant that the pensions were a mere succession of voluntary payments made at the discretion of the former employer. Consequently, in applying the Stedford and Bellow case, McTiernan's dissenting opinion is that the £104 is not assessable income in the hands of Dixon, but merely a series of voluntary receipts. Justice Fulliger acknowledged the importance of the regularity in the receipts in forming his decision, however, found that periodicity is not enough to constitute assessable income. Rather, he looked to the fact that the £104 was compensation for the loss of wages when enlisting in the army. Had Dixon not enlisted, he would have continued to be remunerated credited with £245 and 14 shillings by way of an annual salary for services rendered. By the company making up the shortfall in Dixon's wages, it can be said that the £104 is a substitution for wages and salary that he would have otherwise received. To help with understanding the substitution principle, the case between the Commissioner of Taxation for Victoria and Phillips, as heard in the High Court in 1936, was discussed. Phillips was contractually appointed to serve as the director of a theatre company for 10 years, where he would receive approximately 12.5% of the company's net profits per year. However, after just 6 years, the company sold the theatre and therefore had to terminate his employment contract. It was agreed that Phillips would receive compensation for the wages that he would have received had the contract not been terminated. The amount agreed upon was £20,301 payable in monthly instalments of £404 for the remaining duration of the employment contract. When the case was heard by the High Court, it was held that the monthly payments were a form of the taxpayer's income. When you exchange your right to receipt for a new right of payment, provided it is for the same duration and approximately a similar value, the new such payment retains the character of what it is replacing, therefore income. In applying the case between the Commissioner of Taxation and Phillips, Justice Fulliger conceded that as the £104 are a substitution for salary and wages, it must retain the character of income under Section 25(1). It is interesting to note, prior to his appointment to the High Court in 1950, Justice Fulliger was the barrister arguing for the appellant in the case between the Commissioner of Taxation and Phillips, as just mentioned. As such, Fulliger was arguing the need for amounts paid in substitution for a salary to retain the character of income, to which he is now basing precedence on in deciding that the £104 paid to Dixon to be assessable income. This case is very important to Australian tax law history as it remains an authority in illustrating some of the tests to be performed in determining if amount is assessable income. Essentially, the principles established include if payments are regular, periodic and recurring, or there is an expectation and reliance on the receipts to maintain oneself and their dependents, then the amounts are said to be ordinary income. This principle was endorsed in the case between the Commissioner of Taxation and Blake when heard in 1984 in the Supreme Court of Queensland. The Dixon case was applied to determine that amounts paid by a former employer when supplementing a pension during a high inflation period was assessable on the individual. Justice Carter stated that as a result of the receipts being periodically received every fortnight for several years and used by the taxpayer to cover the cost of living, the amounts are income as per the ordinary concepts. The other principle established was the substitution principle. That is, any money paid to a taxpayer as a substitution or to compensate for either payments or an asset must retain the character of the item it is replacing. For example, payments received from an income protection policy retain the character of income as it is replacing the loss of a taxpayer's salary or wage. Alternatively, a payout received from a building insurance policy would be capital in nature as it is replacing a capital asset. As such, it would not form part of the taxpayer's assessable income. Please note, although not included in assessable income, any compensation received for a capital item may have capital gains tax implications. For example, when receiving an insurance payment for the loss of a CGT asset, a CGT event will be triggered and you will be required to calculate the associated capital gain or loss. Over the years, there have been many cases that have endorsed the principles established in Dixon's case by justices either applying or considering the law to the circumstances present in their cases. So what implications does this case have on offering advice to clients today? Firstly, when a client presents themselves to you with receipts they have received or are about to receive, you need to consider if any of the following conditions apply. 1. Is the payment received on a regular periodic basis? 2. Will the taxpayer rely on these amounts to support themselves? Or 3. Are these amounts compensation for something else or to substitute a different receipt? If the answer is yes, you need to inform clients that they must include these amounts as part of their assessable income. Furthermore, when dealing with clients that are receiving a pension from any source or a client that is considering retiring who will subsequently receive an aged pension, you need to inform them that amounts received will be assessable due to their periodic nature and the fact that there will be a reliance on the money. Secondly, if a client receives a gift from a present or past employer, you need to question the circumstances regarding the exchange. If it is likely provided as a result of the taxpayer's employment or services rendered, then it may form part of the taxpayer's assessable income. As fringe benefits tax has since been introduced after Dixon's case, a taxpayer may be able to argue that such a gift constitutes a fringe benefit, meaning it will be the employer that is assessable to the value and merely included in the individual's non-assessable, non-exempt income. However, if the facts are identical to Dixon's case, would likely be unsuccessful as it was established that the £104 were not provided as a result of employment or services rendered by Dixon. Thank you for listening to my presentation on the case between the Federal Commissioner of Taxation and Dixon. I hope you found this helpful.